Welcome to episode number 224 of AAA Weekly Knowledge Series. We are continuing with our passion and our team is making continuous efforts. Recently, when couple of CIRPs were started and the promoters, in fact, they were approaching us for withdrawal under section 12A, then we thought that this is the section which has actually been used many times since the inception, and therefore we started studying about this section. We noticed that when this code was promulgated on 28th of May 2016, there was no section 12A for withdrawal of CIRP. Then at that time there were two judgments. In fact, the Supreme Court used Article 142 to give a rescue to deserving corporate debtors. The two judgments were in fact very important was Lokhandwala Kotaria Construction versus Nisys Finance. In 2017, the Supreme Court used their power under Article 142. Then in the second case, which is Uttara Food and Feed versus Mona Pharmachem, again the Supreme Court used Article 142 to give a rescue to a deserving corporate debtor. And also in the meantime, directed the government to make a law for the withdrawal. So therefore, in 2018, through an amendment act, section 12A was inserted in the code. So that is what is the beginning, and accordingly regulation 30A, 30 capital A was also inserted in the CIRP regulations, and the process was defined in regulation 30A that the application would be submitted by the applicant, whosoever it may be, under section 7, 9 or 10 application. Form FA would be signed by the applicant. It would be submitted to the IRP or the RP along with the bank guarantee for the estimated expenditure, and then the NCLT, the adjudicating authority, may accept the withdrawal. But there were many cases where the court had started using Rule 11 of NCLT rules and Rule 11 of even NCLAT rules. That was also being used, and parties started approaching directly to adjudicating authority, directly to NCLAT, without even routing it through the IRP or the RP. The settlements were happening in NCLT, settlements were happening in NCLAT also. Thereafter, a very detailed judgment came, and that was in the Glass Trust, GLAS Glass Trust, in the case of Byju's insolvency, where the Supreme Court in fact held that regulation 30 capital A is binding and NCLT and NCLAT should not circumvent those sections, and the application has to move through the IRP or the RP. So that was the law. Now, it was also being criticized that this insolvency and bankruptcy code is being used as a recovery mechanism, recovery tool by many operational creditors, and they are not thinking about the overall insolvency resolution process in case the company is insolvent. But in case the company is solvent, then it should not be used as a recovery process. This has been held many times by various judicial pronouncements that this law should not be used as a recovery tool. So therefore, we have seen approximately 15% of the CIRPs initiated has been withdrawn. That means it is about 1,200 cases so far where the settlement has happened and the applicant has recovered its money, but without even bothering whether the company was insolvent or company was solvent, without even looking into the claims of other creditors, without even understanding whether the other creditors are settled or not. So therefore, a scenario was kind of appearing, and it was showing as if one person will file section 9 and he will recover. In the meantime, while the CIRP is initiated, everyone is filing their claim, so it is withdrawn. Again, after 6 months, another applicant is coming and he actually take away his money and all the claims are again dismissed. And this chain was happening. So therefore, when this Amendment Act 2026 was being made, there was a feedback to the lawmakers that this has to be protected, and the basic objectives was that let this 12A be not used as a recovery tool. Let us understand collectively whether this company is solvent or insolvent. In case the company is solvent, it should not go into CIRP. If a company is insolvent, it should certainly go for resolution, irrespective of the fact whether the applicant is getting its money or not. Applicant's duty is to highlight that this company is not able to pay. In case the other claimants are also saying that this company is not able to pay, therefore this company is insolvent. So therefore this 12A cannot be withdrawn. And in case it is to be withdrawn, then it has to be withdrawn collectively by at least 90% of the voting share of the committee of creditors, irrespective of the applicant, whether he actually gets his money or not. That's what is the new law. So Ankit, do you think that the preamble that I've made, it makes sense? And now, in case you can just let our viewers know what is the difference between the old law and the new law, including the process.
So with respect to recovery, like I always say that the code is frequently used for recovery. When we talk about a resolution plan also talks about how the amount will be given by new management and old debts will be settled and paid for over a period of time. But what is different in the earlier 12A and the new 12A is that the former 12A allowed the applicant to withdraw the application before the formation of COC. So what everyone understood here was that in case the whole objective, which was of course part of the preamble of code also, that the creditors are allowed to file an insolvency application so that those companies or those corporate debtors which are insolvent go out of the normal economy and then they're treated and then they go back to the economy as a treated company. So that was not happening because the commitment to pay or the settlement was happening only between the applicant and the company. So if the company had 100 other defaults, the company would be effectively allowed to be in the economy and disturb other the economy and disturb other good and solvent companies by continuing to do business, continue to take borrowing, continue to default other creditors. So the whole idea is that when you bring a company into CRP, if you look at the code objectives, it is that how do you bring an insolvent company out of the normal economic space and treat it and then put it back into the economy. So that is what is being done, and through that, if recovery happens based on the Section 53 mechanism, based on the order of priority, that's perfectly okay. But what was happening in earlier 12A was that recovery was only happening for the applicant and the company was again sent back into the economy. So with the new 12A, the whole idea of a settlement happening between the applicant and the corporate debtor has been done away with. So earlier, the stages for settlement for various creditors who or various applicants who would apply for or have a Section 7 or 9 application against a creditor would be prior to the NCLT giving a CRP order. So that would be one stage where a settlement is happening. Sometimes we are witness to NCLT proceedings where both the parties come, we are settling, please give us more date. And we have seen that also change now because 14-day disposal is something that now everyone is taking seriously because that is what is the mandate in the law also. And then the second step used to be that after insolvency also settlement used to happen, and every CD used to run to NCLAT asking for a stay on COC constitution. Why? What was the reason why COC constitution stay was asked for was that before COC constitution a settlement can happen. So if the COC constitution does not happen for 1 year, then that 1 year is available for settlement. So then this way the CRP process also used to drag on. So I think this is a good change in 12A that now the COC will be constituted and COC being given a status in the code that they are responsible creditors who will take into account the overall health of the company and pass a resolution plan which is good for all the creditors, all the stakeholders involved. they will now decide with 90% voting if the process happens or not. The second dispute that has been addressed in the new 12A is that earlier 12A allowed the settlement to happen at any stage of the CRP. So let's say the resolution professional has issued the Form G. 4 people have come in now with their bids and with their resolution plans and with their financial proposals. Now suddenly, after looking at the financial proposal, the promoter wakes up and goes to the creditors and says that, oh, the resolution applicants are giving you X, I will give you 1.5X. So please settle with me. So then this was again the reason for dispute. Also, it disturbed the market for resolution applicants, because resolution applicant who has made an effort, maybe incurred various professional expenses to participate in a process, suddenly would be without anything in his hand, and his whole effort would have been quashed by the efforts of the promoter. So this change is also good, that after issuing the EOI, a 12-way proposal cannot happen. The current 12-way now, the new 12-way is silent on if the resolution plan process is closed by the creditor, can a 12-way happen at that point in time? But it simply says that after publishing the Form G, 12-way cannot happen. So it's a very small window now, because technically speaking, practically speaking, the discussion with respect to a 12-way can start happening from the date of CRP initiation. After that, it has to end technically by the 60th day. It can get extended beyond the 60th day only if the COC does not vote on the RFRP. So the COC will have to be consensual to a 12-way discussion in case that process is supposed to happen.
So, Ankit, let us do it a very, very quick kind of discussion. Like, who can submit a 12A proposal now?
The law is very clear. Anyone can submit it. That is how it is written right now.
Law, see, who can submit means anyone can submit, but primarily it is the promoters. Yes, promoter directors, or any shareholder can submit a proposal. Now, it has to be submitted to the RP.
Now, let us discuss why the law is open, but why practically only a promoter will submit a 12-way application. Because when a 12-way application is submitted, it is only withdrawal of the CRP. The directors' rights get restored, shareholders remain the same. So the question is that if somebody else comes in with a settlement proposal, he will come in only if he has some right in the company because of that proposal.
No, technically, only the promoters can submit. Yes. And they can raise funding from some other sources based on their own contractual arrangement. That, of course, we will come little later. But the main issue is that the application for 12A, it can only be submitted before the resolution professional or the IRP, and it can be submitted by the promoters. Earlier, in the old law, it was supposed to be submitted by the applicant who originally made application before NCLT under section 7, 9 or 10. So that's a big difference. Second difference, as Ankit has rightly said, that the period during which this 12A scheme or proposal can be submitted, that is only after the constitution of committee of creditors and before the expression of interest inviting resolution plan is released. This is the T period during which it can happen.
So one submission. So the applicant for 12A who sends an application for 12A proposal to the RP can be a promoter, a director, a shareholder. It necessarily does not need to be all of them together. It can be any of these parties.
Yeah, it can be any
of the interested parties.
See, but
it can be a guarantor.
No, see, since
it can be a guarantor also.
No, since the company is under CIRP, so it cannot be submitted by the company. It cannot be submitted by the company because there is no board.
But it can be a guarantor also.
It can be a guarantor, it can be a director, it can be a shareholder, but it cannot be the corporate debtor because the corporate debtor doesn't have a board. That, of course, cannot happen. Now, you see, the other question which actually we would like to reply very quickly is like the role of the IRP or RP in the earlier law and in the new law. Very quickly.
So earlier law, the RP had a role to forward to file the application after receiving the form FA from the applicant. This is how the law was framed and 12A was framed. New 12A says that the form FA will be signed by the resolution professional. So the requirement for the applicant to give a form FA has been dispensed off with. So now if 90% of the creditors in the first meeting say, okay, we are okay with the 12-way proposal, we vote yes, then the RP fills the Form FA, files an application before the adjudicating authority. No need for the RP to go back to the applicant. So it's a earlier applicant came into the picture or became a problem if the application was filed by a creditor who was not part of the COC. Maybe in, probably an OC who was
Yes,
not part of
operational creditors, they were in fact filing the Form FA or any financial creditor, but now it has to be the Form FA is not supposed to be signed by the RP. It is not supposed to be signed by the applicant, which was the earlier law. Now, this is the biggest change in 12A. Now, there are some changes in the timeline also as per Regulation 30 capital A. Although the regulation name same, number same, but now whenever a scheme or a proposal under Section 12A is received by the RP will have to present it before the Committee of Creditors within 3 days. And then once it is approved with 90% of the voting, the RP will actually submit an application to the adjudicating authority within 7 days, and also the adjudicating authority shall pass an order approving or rejecting the 12A proposal within 30 days of submission by the RP. So these are the various, but the different, one difference is there in process, that earlier it was only the bank guarantee which is supposed to be submitted by the applicant regarding the CIRP cost, fee of the IRP, RP or any other expenditure. Now there is a option of giving a demand draft also, and that demand draft is given for estimated expenses up to the date of submission of the application to adjudicating authority. And in case the adjudicating authority takes more than a month or even a month, so any expenditure incurred during that period, that estimate can be given subsequently to the corporate debtor, and that money will come back from the corporate debtor. Earlier, this money was supposed to be submitted by the applicant, operational creditor or financial creditor, but now this money actually the CIRP cost will come from the corporate debtor, because the 12A's proposal will be submitted by the corporate debtor. So the fee of the IRP or RP is secured. Why it is secured? Because the IRP has already taken control of the company. He has already filed INC 28. He's already taken the control of the income tax portal. He has already taken the debit freeze rights and also the check signing authority on all the bank accounts. So therefore,
already opened the CRP account.
Already opened the CIRP account also, but then CIRP account is opened like maybe the COC with the COC approval, but all this actually makes the fee and the expenditure incurred with the approval or with the ratification of the Committee of Creditors fully secured. So therefore, that issue is not at all
there. These days, banks are opening the CRP account. They only need a PAN card copy. That has become the practical issue these days, that the PAN card or copy is required from somebody, the creditor or the applicant, whatever. Secondly, from practical experience, only from last week's hearing in an NCLT bench where a 12-way proposal was presented by us, if the RP consul, who is again, the applicant for a 12-way application, says that Your Lordship, we have already received all the CRP expenses and we have money in the CRP account or some account which is in our control, which will take care of the expenses till the date of your order.
Yes.
So that is also accepted by the adjudicating authority.
Now, this is all the procedural part of it. Now, we actually would like to discuss today how to use these provisions for a very, very quick resolution of a corporate debtor. We also have seen that in the last couple of days, in the last 1 month, that any 12A proposal with the adjudicating authority is also asking what are the source of funds. Because earlier it was the application by the applicant. So he has already taken the money, whatever the source may be, because he confirms that my claim is settled. So he signs Form FA. Now, the scheme or a proposal under Section 12A is being submitted by the management to the RP. And it may be a case of, say, 100 crores of total financial creditor, 90% voting is required, and the company or the management can go to each creditor saying that my account is regular, I am complying with all the terms and conditions, my account is fully serviced, you vote for this 90%. Maybe two creditors are regular, but one creditor is somehow defaulted. So the corporate debtor or the management goes to that particular creditor, settle it with him. Maybe there are some unsecured creditor, and they can actually also enter into kind of one-time settlement during this period after the constitution of a committee of creditors before the expression of interest is invited. They can actually enter into a one-time settlement with all those creditors. So once this one-time settlement is entered, so that actually will become part of the scheme. In the scheme, each and every creditor would be mentioned, their claim and how the claim is being settled. Somebody can say, though my claim is my account is regular, so there is no settlement required. This will continue as a regular account after the withdrawal of the CIRP. Some creditor will say, it is a default account and I have now given some haircut, and this we have settled with some kind of upfront payment and some kind of installment that is a part of the scheme. And then other creditor, and then the other creditor, and then the other creditor. This is what actually will happen in this scheme. Then the bench may ask for what would be the source of the funds. Now, it is very important that we should focus on one thing, that the company is under the management of IRP. Bank accounts are under the management of, under the operations of IRP. IRP cannot sign a check in favor of a creditor. IRP can do one thing. If the company has funds in the bank account and in the scheme it is written that once the 12A proposal is approved by adjudicating authority, RP can make a commitment in the scheme, in the application, that once it is approved, I will release these funds in favor of these creditors. That is possible. So IRP cannot give payment out of the funds of the company, but can be held by the IRP as an escrow. So after the approval, it will be handed over, and then the company will be handed over back to the promoters. So this is what actually is the we are trying in couple of cases. So this is what I thought that I should share with the with my professional colleagues. So Ankit, what you think about this? Is it possible? So we actually can talk about that the entire scheme. When we prepare a scheme under Section 12, we actually will have to deal with each and every creditor, whosoever is member of the committee of creditors. Secured, unsecured, security interest, without security interest, everything will have to deal with each and every. Then we actually have to mention about the source of funds. Then we also have to say whether there is any haircut or not. We actually have to say everything, and then we actually have to say whosoever has not voted in favor of the scheme, their claims are not extinguished. Even 90% have voted, 10% have not voted. That 10% who have not assented to 12A proposal, their claim will continue with the company, and that they will manage their claims with the company, because the company is a going concern. After this 12A is approved by the adjudicating authority, they would be dealing with the company as an ordinary course of business. They can again deal with the company in whatever manner they feel like, but that their claim is not extinguished. None of the statutory liability is extinguished. None of the operational creditors are extinguished. No claims are extinguished. Filed or not filed, no claim would be extinguished other than those who actually have assented to a 12A proposal. Ankit.
So I think yes, you're right that the any settlement proposal, in case we, let's say, even off IBC, in case there is an OTS, the OTS proposal simply says that okay, this is how the settlement is proposed, and if there is an acceptance from the creditor on the OTS proposal, it is always subject to fulfillment of the obligations that are stipulated by the other party. So I think it will function similarly. I think we have also seen many 12A applications or other orders where the adjudicating authority has passed an order under Section 12A saying that in case the commitments that have been made by the company or the promoter are not fulfilled, then the applicant or the creditors will have the liberty to file the application for insolvency again. So that is there, and of course, you're very right that the it should be binding only on those who are voting in favor of the OTS proposal or sharing an acceptance on the settlement proposal under 12A. Technically, it cannot be binding on other creditors. So one question that of course comes out is that now with this new 12A, the decision is with the COC members. Now, if there is a situation where the COC members are okay with a 12-way settlement proposal, whereas the operational creditors are not talked about in the settlement proposal at all.
No, see, you mean to say that Section 9 applicant?
Yeah, let's say
Section 9 applicant is not even bothered. This is like
Not
he is
even
not
talked
even
about.
he is not even talked about in the
in the
process.
12-way proposal, and the financial creditors who are part of the COC meeting approved that 12-way settlement. Now here, the whole procedure is withdrawal of application, but the application was of the OC. But technically, you have given withdrawal of an application right, which was filed by somebody else to the COC members.
To the COC through RP.
Through RP.
Through RP.
Through
So
RP.
the role of the applicant is extinguished completely. Now, therefore, when I started this episode today, I said that the lawmakers never wanted that this law to be used as a recovery tool. Now, the entire COC has decided that this company is solvent or this company is settling so that our claims, so that this company, even after solving this company will become solvent. So if there is any other claimant, statutory dues, income tax dues, GST dues, operational creditors, all will continue with the company as an ordinary course of business as they were continuing earlier also. So if there were any dues and that those dues are still not paid and those dues are still not disputed, the only thing that I'm trying to say that the Section 9 applicant, even after the 12A proposal, which is approved by the adjudicating authority, can again file a Section 9 application to restart the process. So that is the only like kind of which is a little flip side of it, because see, one applicant under Section 9 is not settled, but the entire COC is settled. 90% of the COC is settled. His claim is not extinguished. He is continuing as a operational creditor who is in where the CD is defaulting. Now he again will file an application. He again will file an application, but the COC will again say 12A. So therefore, the lawmakers are very clear that this applicant who actually wants to recover some amount cannot use IBC while the other creditors are okay, satisfied with the conduct of the company.
So I agree with it. I agree with what you're saying. My only thought process is that where the applicant kind of goes back to NCLT and does say that I am not satisfied with this proposal, it will again be subject to adjudication at the NCLT. So my thought process has always been that in the settlement proposal under Section 12A, which is submitted by the promoter to the financial creditors who will vote in the COC meeting, they should for sure talk about how the company has sufficient assets to take care of these liabilities, which are OC liabilities. If there are certain disputes with the OC parties, maybe that can also be talked briefly in the proposal, so that the NCLT, when they're deciding on the 12-way proposal, get a complete view on how those creditors are also going to be discharged over a period of time.
So therefore, the 12A proposal is going to be a very kind of accomplished proposal. Accomplished proposal where the each and every debt of the company is mentioned, which will get settled and which will continue and which will not extinguish. So all this is now this is the 12A. In fact, earlier it used to be a one-page form. Even the form is today also it is a one-page form.
Yes.
But along with that form, there are many things that has to be stated in the 12A scheme. It is a new opportunity for the IRP and the RP that the 12A proposal or 12A scheme, it has to be prepared in such a manner that it is acceptable to the adjudicating authority, because if the adjudicating authority is not satisfied, the adjudicating authority may reject it also.
So in the recent application that we filed, we talked about all the COC meetings that we had. We talked about when the 12-way application came to the RP, how it was shared with the COC members, how they voted on it. We also talked about the assets that were taken possession of by the RP, what are the total claims that are received, what are the liabilities which are known from the financial statements or which claims are not received. So we went to the adjudicating authority with absolute clarity on everything that was available on record, so that the NCLT can take a conscious call that yes, overall a 12-way settlement for this matter will be in the benefit of the company. We also mentioned how the company is a going concern, what kind of business does it do, how a prolonged CARP will be detrimental to the overall interest of all the stakeholders. So we talked about all that in our application.
And we have also seen a very, very intelligent 12A order. Just a day before, we saw a very, very intelligent 12A order. It was from Kochi bench of NCLT. And we are trying to say that whatever we are saying, it is absolutely the same, because the order itself writes what is extinguished, what is not extinguished, what will continue, and why this proposal is being accepted.
It's a very clear order.
Very
that no
clear.
relief for any creditors. All the statutory dues have to be paid. No relief from income tax during CRP period. So I think very, very, very well elaborated order which talks about all the rights and makes it very clear that nobody should be able to misuse the 12-way.
See, now let us discuss, Ankit. Do you think that this particular window, after the constitution of committee of creditors until the expression of interest is invited, because in case the creditors would be interested, actually they would delay the expression of interest invitation. So we can say that there is 1 or 2 month window is available. So if a company thinks that it is an opportunity, and the banks also think that it is an opportunity, can this actually become a window for one-time settlement, and also with the third-party investment?
Yes,
with third-party investment.
So my understanding is that third-party investment can come in here, and I have I have reviewed the code regulations, and I don't think there is any barring on the possibility of an agreement to sell for the existing shareholders to dilute their shareholding. So let's say companies in CRP and the promoters want an investor's help. Now there are 2-3 ways in which the investor can come into picture. Either the investor comes in through a share subscription agreement. Now in case of a share subscription agreement, the company cannot be a signatory to such an agreement because the company is under insolvency and under the rigors of CRP. So the RP will never be allowed to sign a share subscription agreement. But what the promoter can do is that the investor can do is that the investor can come in through a secondary sale of shares and an agreement for secondary sale of shares, in my opinion. So there, some investment can come in, which then the promoter can infuse or rather pay to the creditors on behalf of the company, and accordingly the agreement to the share purchase agreement can actually be prepared with a condition that it will be enforced with respect to share transfers once the 12-way application is disposed and allowed by the NCLT. So this is one way where an investor can come in. The second is, of course, where an existing promoter or a shareholder says that, okay, I have money. That I think is more likely. Sometimes, there are multiple stakeholders in a company. One stakeholder can say, I have money, let me rescue this company, and I want to enter into an agreement with other shareholders with respect to transferring their shareholding to me. So that is again possible. Several times, there are mixed shareholding, because of which one shareholder might have money, others might want to sell off their shareholding to that one person or transfer it to that one person in order to kind of get the company out of CRP. So that's another way that I feel is possible. The third, of course, is an individual loan where the investor says, okay, you pledge the shares to me and I will give you the loan. So do you think there is anything that does not allow the current shareholders to pledge their shareholding to an investor?
No, see, the section 28, I believe, deals with the shareholding pattern. So, what I have in mind, like selling the shares by the promoters during CIRP, that maybe it actually will be considered as violative of section 28. But what I'm trying to say is, see, first of all, let us understand there is a third party which is coming as investor and taking a substantial shares in the corporate debtor, which is under CIRB. So the first step would be to settle with the creditors and execute a settlement agreement. And the settlement agreement will have all the conditions, all the upfront payment details, and all the details which are with the deferred payment. The second thing would be to sign a share subscription agreement or even a partnership agreement with the investor. And the effective date of that partnership agreement or share subscription agreement would be the date on which the adjudicating authority will approve Section 12A proposal. While these two agreements are made, the amount which actually would be given to the financial creditor COC members, that actually can be kept in an escrow account. And then the escrow account conditions can be, if the 12A is approved, this money will go to corporate debtor. If the money is not approved, this will come back to the investor. Then there can be documents regarding the release of the personal guarantee or the further pledge agreement, the security interest release in case there are personal collateral securities. And then once the 12A is accepted, and it is withdrawn, that means the very same hour, very same minute, the board of directors are in fact start having power. Then immediately the board of directors will pass various resolutions, whatever is required for the deal to be fructified, and then immediately the payment can be made to the creditors. So now the creditors are also settled, the investor is also protected, the escrow account and can be used for making payment to the creditors, they are also secured, and all other the release of pledge, further mortgage documents, release of personal guarantees, further providing the personal guarantees of the new management, all that can be done with an effective date which is consequent to which is an event on approval of adjudicating authority. So this is what is the also structure in case there are investors, it can also be done. So Ankit, any gap in this?
One addition there, I just went through regulation 28. So it simply says that section 28, and it says that approval of committee of creditors is required in these cases, and it says approval of COC is required for change in the capital structure of the corporate debtor, including by way of issuance of additional securities, creating a new class of securities, or buying back or redemption of issued securities in case the company CD is a company. And then it says recording any change in ownership interest of the corporate debtor also requires the committee approval.
So where
the committee is approving a 29A, they can easily approve this also.
They can approve the
change in
the capital structure also. So this is a completely a process which can be developed. The company can be resolved with a third-party investment within this period, within this window, post-committee constitution, before the expression of interest is invited. It is legally possible. It is practically also possible. That is what we actually wanted to say in this episode number 224. But yes, still there are more facts so that we kind of elaborate more about this opportunity which is available to the management and also to the
creditors.
Also to the creditors.
Because the creditors get out of the process. So
because the creditors, instead of going for a longer litigation, they can actually settle it within these first 2 months. So we actually can go as we have already said that the promoters, grantors, any related parties, they can actually settle. Yes, they can settle. And the investors that we've already said that yes, investors also would be possible. So what we are trying to say is that, as Ankit has rightly said, that it is actually beneficial to the creditors. In case the creditors are able to settle within the first 2 or 3 months and they actually can get their money partly upfront, partly deferred, I think that actually will be better than the resolution plan. But the only difficulty I could see that during this process, the valuation would not be done. Banks or the creditors will have to depend upon their existing valuation in their records. So they cannot have the new valuation because this period, the valuation report may not come during this period.
Now, even if the valuation report comes, technically as per the regulations as of now, the valuation report is not supposed to be disclosed to the creditors till the resolution plans are opened. So that is the hurdle for the RP's valuation reports to come to the COC members. So therefore, the COC members will have to get a valuation done in their internal department.
In their internal department.
Because the problem is not the valuation report will not come. It is possible for the valuation to be approved or the valuation fee to be approved, appointed at the, let's say, 35th day, 30th day. Practically possible, and maybe the report can also come within a few days if the cooperation from the management is coming in. But the technical problem is that as per the regulations, the valuation report is not supposed to be given to the creditors till the resolution plans are open.
Yes, I think this is again a discussion
Yeah.
paper which is still in
Yeah.
process. Maybe that it will become a
Even
transparent
as
process.
even as of now, that is what is required. That once they give the undertaking, only then it is opened at the time of resolution plan approval.
Now, Ankit, another question somebody asked me, and it is important that we should take up this question. Now, suppose in 12A scheme or 12A proposal, there is some upfront amount and there is something which is deferred part. Now, upfront amount is given, voting is done, the company has come out of the CIRP, the management is enjoying the company again, but there is a default in the deferment. In the deferred payment schedule, there is a default. What are the options available with the creditors, again, who are facing the default for the deferred part of the settlement?
So we have personally witnessed a 12-way settlement where the CD was our IPE triple insolvency was the appointed IP, and we have witnessed that the proposal came in and the proposal mentioned that if the settlement fails, then the applicant will have the right to take the company to CRP again. And this was argued before the adjudicating authority, and the adjudicating authority in their order mentioned that in case future settlement obligations are not fulfilled, the applicant has the right to come back and restore insolvency or CRP of this company.
So there are two things that we have as support. One, that the Supreme Court judgment in the case of VCF Kalas,
Yes.
that judgment, I think you take out that judgment. In the meantime, I will just say that the judgment of Axis Bank Limited versus Chintamani Jewelries Arcade Private Limited, it is a judgment from NCLAT, and this judgment is only given in last week. Only last week judgment, where in fact the settlement under section 12A was done in 2024. Some part was paid to the Axis Bank and some part was deferred. Now after about a year, the deferred part was again defaulted. So the Axis Bank filed an application to NCLAT or NCLT, and it was NCLT, and the original CIRP was immediately restarted. So it is therefore the CIRP is again restarted. Wherever it was earlier withdrawn, it is restarted again. So therefore, anyone who actually has paid substantial amount, any corporate debtor will not afford to have another CIRP in case he's already paid the substantial amount. So that is a judgment of Axis Bank Limited versus Chintamani. I think you can also say this judgment of
This is Valal RCK versus MS Siva Industries and Holdings Limited, and this is again from the Apex Court. This judgment is, of course, dealing with the rights and duties of 12A, and it's a judgment which is dated 3rd June 2022. So fairly old judgment, but still talks about how 12A works and has to be read with the new 12A, of course, because it always referred to the former 12A.
See, one more judgment that I would like to say today, which is again a judgment given in July 2026 in the name of Oswal Overseas Limited versus LH Sugar Factories. It is a judgment from NCLAT. Now, in this case, the operational creditor having a dues of about 2 crores finally went to NCLAT and offered that amount in the court, and the NCLAT is passing the order that okay, this is settled between the parties. Now the NCLAT gave directions to IRP. Earlier it was state. It was stayed for some time, and then now the directions are, earlier the IRP was restrained from moving forward. Now the NCLAT says IRP to invite the claim, verify the claim, constitute the committee, have a voting of 90%, and in case the voting of 90% is successful, then submit an application to adjudicating authority. So that means even after paying to the operational creditor before NCL 80, the corporate debtor is still struggling to get 90%.
Still requires to pay the financial
Still
creditors.
struggling to get 90% voting share. So therefore, a recovery is not the objective. Payment to operational creditor is not the objective. See, that particular operational creditor is lucky that he offered in NCLAT and the operational creditor took it away. But even after taking that 2 crores of rupees, the corporate debtor is still struggling to get 90% voting share. So this is what is the implementation of the new law by NCLAT. This is also very important to understand that the new law is being implemented in this manner. So I think this is all that we wanted to discuss. Anything else which is coming in your mind? Any question? Because the entire process that we have seen, we actually see. So I think we can conclude that there is hardly any difficulty. The operational creditor or Section 7 applicant. A Section 7 applicant, in case he is a part of the COC member, he will get, because of 90% voting share, he will get his share, maybe with or without haircut. And in case he accepts a haircut, the balance will be written off. In case he gets full amount, it is okay. 10% who have not voted, who have not accented, their claim will continue to the company and they will deal with the company in a normal course of business, ordinary course of business. The operational creditor who actually has originally started the application under Section 9 is not a part of the committee of creditors. His voting is not included in 90%. So he would continue with the company as a ordinary course of business, as an ordinary creditor, and will deal with the company in normal way. So this is what is the new 12A. Opportunity for the creditors, in case they can get it settled, then it can be concluded within 2-3 months and the company is happy, the creditors are happy, and in case there is any acquirer, in case there is an investor, this is the fastest route of coming out of CIRP, still enjoying some kind of haircut, because the creditors may like to go through this shorter route. Thank you very much.
Thank you. Thank you so much.